When does a lawyer not take a client's case? And let me give you some thoughts about that as to what we think about when we assess a case and whether we take a case or not take a case. A couple of things. One is the case a meritorious in law? Does the law of Virginia support a claim as the client presents? If there is no basis in law, of course not. We don't take that kind of case, and that would be certainly a waste of effort for you as well. Do the facts, another thing that we analyze are the facts. Are the facts supportive of a claim? That kind of mirrors and marries with Virginia law and to see if the facts are supportive of a legal claim. Does the lawyer, another criterion, does the lawyer have a conflict of interest? Does the lawyer know the defendant, for example? Does the lawyer do business with the defendant doctor? So those are some of the criteria to determine whether the lawyer takes the case or not. The last thing to determine and think about is whether the damages that the plaintiff suffers, the client suffers, is sufficient to support a claim. And a lot of that is determinative of, I'll give you a good example. In an auto wreck case, if the client goes to the emergency department, has that treatment, the next day they feel perfectly fine, everything is fine, they do have the emergency department visit. I normally don't take cases like that because my job is to add value to your case. And in those circumstances, very limited circumstances, most of the time a lawyer doesn't add value. And so therefore the lawyer doesn't take that case or shouldn't take that case. That's a good example. So that's the criteria. Does the lawyer have a conflict of interest? Does the lawyer see that there's a meritorious claim under Virginia law based on the facts? And third, is it worth pursuing based on the damages presented? If you have any questions, please give me a call. I'm happy to help.